Session, Justice Carlisle presiding.
Good morning. Welcome to the criminal docket here on the Fifth Court of Appeals. Mr. Anderson, looks like you are solo today. I don't know if you've had a Zoom argument yet. These we found to be very productive and just about the same as our in-person arguments. If you experience any difficulties, let us know. If you have suggestions afterward for how it might work better, please let us know too. We'd love to be refining this process as we continue. We've got 20 for you. We can be flexible today on this case as we have just you, as I said. So I'll call the case. We've got 05191133CR, that's the state, versus Darin Johnson. Mr. Anderson, when you're ready.
Thank you. May it please the court. While it is not unusual for a trial judge to disagree with the lawyer's chosen trial strategy through the course of litigation, such disagreement should not result in giving a criminal defendant a mulligan when defense counsel clearly articulates a strategy, that strategy has a plausible and professional basis in law, and there is a lack of evidence in the record to reflect that counsel's strategy poisoned the trial's outcome. Unfortunately, in the case now before this honorable court, appellee was granted such a meritless do-over, which is why the state appears before you requesting that the trial court's order be vacated and the jury's guilty verdict be permitted to stand. Through 6 days of trial, with over 300 exhibits and 22 witnesses being asked questions by 3 different lawyers, appellee requested a new trial after being found guilty based on responses to only 8 questions that had been asked during the entire proceedings. The trial court granted appellee's request based on 4 of those questions, each making references to previous encounters with federal authorities. 3 of them were statements that came from the co-conspirator Dixon's statements that he met appellee inside federal prison. And the 4th was a prior statement by Officer Nelson that he was familiar with appellee through a 2014 prior arrest. During the hearing for a new trial, appellee's trial counsel stated in response to all of these questions that he did not raise a contemporaneous objection to the responses because he did not want to draw attention to them. That was a strategic—
Can I stop you right there, Mr. Anderson? This raises a really interesting point to me. We have, on direct appeal for once, a record that it appears perhaps we can actually evaluate this claim, number one. Number two, in the midst of the trial, much closer to the heat of the moment, counsel more or less didn't even try to give a reason for this, other than to kind of apologize and say, I missed it, for not objecting. Then we have conflicting testimony at the hearing, which you've just recited. How do we deal with a trial judge's assessment of that conflicting testimony? And how could it lead to reversal for the state?
Well, the state's review of the evidence doesn't believe that the testimony was that conflicting. First, if you look at the testimony that came from trial counsel during the hearing, he's pretty consistent throughout the hearing that he did not object because he didn't think it was it would draw too much attention. And it's
right. I understand during the hearing, but I'm highlighting the in trial, like the mid trial, where he said, "Look, I'm sorry, I missed it."
Well, he didn't say that he'd missed it. Well, if you look at you look at the transcript, and I think it's, if I recall correctly, it's volume 6, page like 5 to 7. He talks about how he didn't have a good explanation. The court responds that, well, and this is the day after that they had the actual bench conference, which is not on the record whatsoever. And during that recollection of the bench conference, there's a back and forth about, well, the trial judge says, well, maybe you didn't want to draw attention to it. And trial counsel's response is exactly. So he puts on the record, even at that time, that his reason for not objecting was that he didn't want to draw undue attention to it at the time. And the only place within the record that it states that he missed it is in the footnote to the trial court's order. It doesn't say that inside in the record. There wasn't testimony about it. And when the trial court had the opportunity, and there was a part during the portion of the hearing on the motion for new trial where the court comes out and gives a statement about its recollection of the bench conference, but it doesn't mention anywhere in that recollection any statement about trial counsel saying he missed the objection. It was addressing the issue of whether or not the questions were brought out to taint the jury or were something planned by the state to draw out those questions. And so that was never corrected. The trial counsel for the state, the prosecutor, was the same in both hearings. He made no efforts to try to correct if there was a misstatement by the trial counsel during his testimony to correct any potential misstatements about missing an objection or not stating clearly that he missed an objection, and that didn't happen. And so the record, as it reflects, does not support a conclusion that he just missed it.
Mr. Anderson, let me ask you this. What do we have to do? We're dealing with a call that the trial court made after a lengthy trial with multiple exhibits and witnesses, as you have pointed out. What kind of hoops do we have to jump through to find that Judge Birmingham abused his discretion in granting that new trial? I mean, are we just, it's almost if you're asking us to take a general de novo review of this entire proceeding. And as Justice Carlisle points out, we do have a record in this case, which is very unusual. And the trial court heard this testimony and witnessed the entirety of the trial. So tell me how are we permitted to just say, well, your wide leeway on the abuse of discretion standard in granting a motion for new trial is just wiped out because we view it differently?
Well, it's more than the state just viewing it differently. Two of the big problems that the state has with the ruling and why it believes that there is evidence of an abuse of discretion has to do with the standard that the court used in order to come to its conclusion that, one, there is deficient conduct, and two, that there was prejudice under the Strickland analysis. So if you look at the trial court's order, and it's on the very first page on, I think it's 137 in the clerk's record, it defines, the trial court gives a definition of deficient conduct. And that definition, as it states, and I'm going to quote here, it says, under the first comma, the deficiency prong, comma, the defense must prove that counsel's performance was, in quotations, deficient, that there were errors so serious that counsel was not functioning as counsel guaranteed by the Sixth Amendment. That's how the trial court defines deficient conduct. But the true definition of deficient, and while that may be a fair overview of what the whole idea and the concept behind the protections of the Sixth Amendment and ineffective assistance counsel may be, the actual definition of what defective conduct is found under Moore. And that is conduct that fell below an objective standard of reasonableness under prevailing professional norms according to the necessity of the case, or as reticulated in Bone, that there is no plausible professional reason for a specific act or omission. And in the record, the trial counsel gives us that plausible professional reason. He did not want to draw extra attention to this. And it's a faulty definition.
What if the district court did not want to believe his testimony?
If the district court did not want to believe his testimony, then there is still a problem on the prejudice prong. Under the prejudice prong, the test has to be established under Vaughn that it would have been error for the trial court to overrule the objection. In other words, to allow this evidence in over the objection had it been made. But the test that the trial court applies is subjective. It says, look, and it says, again, on 137, if the objection was made, the trial court would have sustained it under a 403, 404 analysis. And the state's not saying that that's outside of a zone of reasonable disagreement that they could do that. However, that's not the question to ask. The question to ask is, would it have been it would have been wrong for him, the trial court, to not grant that objection, to overrule it. And that's not the question that was asked. So the court says, I would have overruled it, therefore there's prejudice, therefore there's deficient conduct. But that is not necessarily the case. And the state has referenced in its opening brief and its responsive brief cases from other authorities that say that there are situations
Mr. Anderson,
information could come in.
Are you really pushing that? I mean, it's how many angels can dance on the head of the pin. I mean, after the fact, in theory, we can figure out a way that could have been admissible. Are you serious about that? I've looked at this. All this was character evidence. It didn't just, the way you use relevance, it seems to me, is like everything's relevant to everything else. I mean,
no, and that's not what the state is arguing. It's not relevant. It's the key here is that it should have been an objective test, and the court did not apply an objective test. It applied a subjective test. And by applying a subjective test, it doesn't do the actual analysis that it needs to make the conclusion that there is defective conduct in this case, or that there is prejudice. And the example is that, the statements that came in, there was really no, they could have come in if the state had wanted them, because the heart of the issue at this case was identity. And that was the primary defense that appellee was pushing throughout the entire proceedings. You can't believe Dixon because he's not credible. You can't believe Johnson because he's not credible. And so therefore the state only has this circumstantial evidence in order to show that the appellee committed these acts. But so by making identity an issue, then when Dixon explains how he knows them in very broad terms, he doesn't even go into really any detail about, the jury at that point did not know what he was in federal prison for, how long, and really in the blink of the duration of Dixon's testimony, it was really a blip on the radar. So,
but it's not one blip, Mr. Anderson. We're talking, like, I hear you if this is an appeal based on one non-objection, but it's just not. And that argument that you've just made completely ignores that. And so, fine, one isolated instance, but I think there is common ground that this is generally objectionable testimony. And the state doesn't dispute that. Okay. And I didn't think so. That'd be bad. And so we move on from there, and we have this, we're not quite to a point of pervasive conduct by the lawyer in not objecting, but we have several episodes of non-objection. We're on a continuum in terms of, gosh, it wasn't just one, but it wasn't 50. And so we have testimony that, yeah, I hear you, I've been in your seat. The state can find a reason that this testimony might have been admissible. But also, the guy the Dix, the accomplice, didn't need to say it was in federal prison to make that testimony persuasive for the state, right?
I agree.
He could have said, I spent 4 years with him in close quarters or whatever. Some sort of sanitized version. And so, I've made a statement, and there we go. But moving on from that, you talk about the prejudice inquiry that the court did incorrectly. So walk me through what you think the correct prejudice analysis is.
Well, before I dive into that, I just want to make clear. So when I'm saying blip, I do recognize, and state does recognize, that there were, like you said, there was like about 6, give or take, instances where this information came out and he didn't object. But when you look at it in the context of all of his testimony, it's really at the beginning of it, within really one paragraph of all of this testimony. So when you're thinking about it in the context of the trial as it is going on, it comes out, trial counsel decides not to object, and then they move on to what the state's purpose is with Dixon, which is explaining how this gang, this combination worked, and how they were organized and all of that. So that's really the reference that I'm making. If you take it in kind of the context of how this is going along and the pace of the trial, I don't think that it is an implausible decision for trial counsel that time to say, maybe I don't want to draw attention to that right now. But then turning directly to your attention, or excuse me, to your point about prejudice, again, the issue here is, I mean, the issue under Vaughn, first of all, as we've been talking about, is whether or not it would have been error for the trial court to admit it. Now, the state, the reason that the state is providing this case law to the court for consideration is to show that it is within the zone of reasonable disagreement as to whether or not this information could have come in the first place. And if it is within that zone, and the state's position is, then it's not prejudicial because the court could have ruled either way. I'm not saying that the state is not arguing that the court would have ruled incorrectly had they sustained the objection, but the test is not that whether or not it would have ruled incorrectly had it sustained it. Would it have ruled incorrectly if it had accepted this evidence into the record? And the
But it
answer
just
to that
strikes me, counsel, as providing, an entirely other layer of outs for a court to post hoc justify conduct that at the time was hard to explain, to put it lightly. Why would we import an evidentiary test on top of the prejudice prong, to make it even harder to find ineffective assistance? How do we talk me through that one?
Well, I mean, that's how you have to analyze whether or not, I mean, that's the test that's set out in Vaughn. Vaughn says that in order for there to be, in order for trial counsel to be found ineffective based on a lack of objection, then it has to be shown that for the prejudice prong to exist, then it would have been error for the trial court not to sustain the objection. And in order for that error to exist, then you have to decide, well, what is this the type of evidence that the trial court could not within its discretion allow into evidence? And so it is the law kind of absorbs that analysis. That's why it's an objective test. You have to go through that kind of consideration in order to find whether or not that there's prejudice. And that wasn't done in this case. In addition to that, you have a very unique case in this situation where
Well, counsel, I have a question. With regard to, I'm similarly having conceptual difficulties with how the prejudice prong of the Strickland test is met, beyond what you pointed us to in the briefs, the fact that there were identical outcomes in terms of sentencing. What else, if anything, can you point us towards in showing or meeting that prejudice prong?
Well, I think in addition to the facts that we've talked about under Vaughn, again, there is, as you pointed out, there is the identical outcomes, which is very unique, and which I was considering, which is why I paused a moment ago about whether or not to go down that road, simply because of time constraints. But the other part, I think, is that there was nothing in the record either on in the hearing itself or in the responsive brief by appellee that really addresses the prejudice. It's simply assumed. And I don't think that that's the correct standard that they had in mind when you're applying a standard, an objective standard to a deficiency test. There has to be some kind of objective analysis, and not just assuming that just because there was a failure to object to evidence that could or could not have come in and contemporaneously object. Because we have to remember also that at some point, trial counsel does actually bring this up, the question, to the trial counsel's or to the court's attention, does ask for a motion to ask the court to order the jury to disregard, gets that after making that objection and getting that corrective action. And then at the tail end of it in the jury instruction gets further instruction that says, the extraneous instruction that they can't consider it. And all of that is
Well, so let me ask you this. I hear you on that and where you're going. But what do we do with that? I mean, the lawyer said, I didn't want to bring attention to it, but then now you're telling us part of the reason we shouldn't find a problem is because he got the instruction that theoretically was meant to bring attention to it.
And that was
the trial
actually,
court went against, your position. So on this abusive discretion review, why does that make us have to flip the decision?
because it's strange to have a case where you have a Texas lawyer that is being held responsible for ineffective assistance for not making an objection when he made an objection.
I mean, fair, I hear you on that point. It seems like we may end up in a circle on that at some point, and maybe not in this case, but maybe in the next case.
And I think that what we're seeing here as a practical matter from a trial standpoint is at the time that the statements came out, trial counsel is thinking one thing: I don't want to bring these out and draw them out. There's a bench conference with the trial judge after the end of the day that's called by the state, and during that conference, it is relayed that to trial counsel that maybe the case isn't going quite the way I think of it. Maybe that it is time for me to train strategies in order to best aid my client. And so after thinking about it overnight, he comes back the next day with that very point in mind and says, all right, well, let's address this now. Maybe the tactic I have been using up to this point wasn't very effective. Let's change it. And I think that's kind of what you're seeing in the record as it plays out. But that, to me, does not say that this objection, after thinking about it, is untimely. Or that it was incorrectly placed. And even, when it comes to timeliness for an objection, this court has stated in Anderton that as long as it's brought to the court's attention at a point in time where they can do something about it, then it would be a timely objection. And the court did that in this case twice.
All right, thank you. This was any other questions from the panel?
I do have one question. This objective analysis has me mystified, Mr. Anderson. Did you point us to any controlling state authority that said that this information was admissible in a situation like this? In the briefs, the state has not been able to find any controlling state authority on that point. There is federal persuasive authority on that point, and I think it's pervasive because the federal rules, the Texas rules of evidence, are also based on the federal rules, and their standards are very similar. And I think, especially in light of the fact that very little information came out about what he was in prison for. You can question whether or not the jury can come to a character reference based on a propensity to act a certain way if they don't know what the certain way actually is. And so I think that's why it's persuasive. But to answer your point directly, no, the state has not been able to find direct state authority on that issue. And one final question: it's that this potential admissibility that feeds into your objective analysis argument, correct?
Yes.
On the prejudice prong. So it's objectively reasonable if we can somewhere find a case that supports the position, or put another way, if we can find a case that doesn't exclude the position. You see what I'm saying?
I do. And what I think here is that these questions should have been asked at the trial level, and they weren't, because the court used for a subjective test. And if these questions are asked at the trial level by the court, then they can go through this analysis so that the appellate courts don't have to have these types of hypothetical questioning and trying to just figure this out. And that's really what the problem is. It's the subjective application of what should have been an objective test. And that's where we run into the issue of abuse of discretion and finding ineffective assistance in this case.
Thank you. Thank you.
Thank you. The case will be submitted on the argument briefs. We appreciate you coming in today, Mr. Anderson.
Thank you for having me.